Currently, we have 4 anti-discrimination ordinances in Hong Kong. These aim to protect discrimination against sex, disability, race, and family status. Although it covers actually a wide range of things, in this particular instance, I think we're more concerned with prohibiting all these discrimination in the workplace. The Sex Discrimination Ordinance actually also covers pregnancy and sexual harassment. The Disability Discrimination Ordinance covers both physical and mental disability. Race discrimination covers discrimination on the grounds of ethnic origin and color, but note that it actually excludes the discrimination on the grounds of nationality or residency status. The Family Status Discrimination Ordinance prohibits somebody being treated less favorably because they have a responsibility to take care of an immediate family member, such as an elderly or a small child. Discrimination can also be direct discrimination and indirect discrimination. Direct discrimination is pretty obvious. That means that you're treating someone less favorably because of a particular attribute. Indirect discrimination is a bit more tricky because you can be caught if you try to discriminate someone not directly, but because of a particular attribute, that person is most likely to be not able to fulfill certain criteria, thus be treated less favorably. That is also covered by the 4 anti-discrimination ordinances. It's particularly for employers to have policies in place for equal opportunities. The reason is that the employer is vicariously liable for their employees by law, and so they could actually be held responsible for what their employees do in the workplace. Currently, the law doesn't cover discrimination on grounds other than the ones that I've already mentioned. There is a guideline on discrimination on the ground of age, but it is only in the form of guideline. That means that it doesn't make discrimination on the ground of age unlawful. In a continuing effort to combat discrimination that exists in society, the Equal Opportunities Commission, which is actually the commission that regulates or is responsible for monitoring the compliance of these ordinances, they would like to promote anti-discrimination on other grounds as well. Definitely there are developments. Most recently in May of this year, the Equal Opportunities Commission started a feasibility study on legislating against discrimination on the ground of sexual orientation, gender identity and intersex status. The study aims to systematically identify the extent and forms of discrimination experienced by people with different sexual orientation, gender identity, and intersex status, including lesbian, gay, bisexual, transgender, and intersex people in Hong Kong. The study also seeks to explore the feasibility of actually legislating against discrimination on grounds of sexual orientation, gender identity, and intersex status, taking into account the perspective of sexual minorities and other stakeholders in the society. And in fact, just 2 days ago, the EOC announced that together with the Chinese University of Hong Kong, they have launched a website to promote public understanding on the study, purposes and content. Presumably, once the study result is available, then the next step is for the EOC to recommend to the government to possibly legislate for our 5th anti-discrimination law. The EOC has issued a series of useful supplements in addition to the legislation in the area in particular of employment. They include the codes of practice of employment, one each actually for each of the anti-discrimination ordinances. And there's a good management code of practice, guidebook on equal pay, on work of equal value, etc. However, these supplements, including the code of practice, they're not law, so they actually don't have any legal effect. However, employers are encouraged to follow the guidelines and the code of practice recommended in this code, unless there are justifiable grounds for not doing so. In fact, if an employer does not have a reasonable excuse not to follow the code of practice, that could be an adverse inference on the employer. As mentioned, the employers should have policies in place for all of the anti-discriminatory grounds. I would say whether or not they are legislatively prohibited or they are, coming up new grounds of discrimination. The employer should have policy with clear definitions of what each of the unlawful grounds are, a statement of the company's position in relation to discrimination, and also they should have a written policy, a procedure to deal with any complaints received by their employees. Companies should also make training on this subject to staff available, and in fact I think they should actually make it compulsory, as this would give the employer a very good ground for defense in case a claim is being brought by the employee against the employer.